Any more on Pishalnikov?
No, my Lord, thank you. My Lords, can I perhaps just mention one matter arising from the decision? I drew my Lord's attention to the reasoning at paragraph 81 in Pishalnikov. I simply wanted to, if I could, my Lords, conscious of the time, indicate to my Lords that that reasoning in paragraph 81 was cited in Pavlenko against Russia, volume 6, tab 137, at paragraph 118. I hadn't intended to take my Lords to it, but just to indicate that that reasoning had been deployed again at 118.
Yes.
So what was that? Tab what, 137?
That was tab 137, my Lord, at volume 6.
And what was the paragraph number?
118.
Thank you.
My Lords, I mentioned this case briefly this morning, but I wonder if I could come to it now, my Lords. It's Zychenko against Russia, volume 6, tab 161A.
Sorry, just give me the number again.
Yes, it's 161 capital A, my Lord. It should be the last in that bundle.
Yeah. This is the most recent of the collection so far.
It's, it may almost be, my Lord, it's the 18th of February of this year in any event. Of course, as soon as I commit myself to that, my Lord, I'm helpfully reminded by my learned junior that Pavlenko is the 1st of April, so I'm sorry.
Oh, was it? Oh, I see. Thank you.
Lord, this is the case I mentioned in passing, Lords. I don't wish to take up too much time going through it, but this is to show that there are some limits to the principles applied in Saldus. Lords, at paragraph 14 on page 4, the Lords will see something about the background. Basically, the applicant was stopped for a roadside check by the police because there had been, broadly speaking, complaints about fuel being stolen from his employers. Lords will see that at paragraph 14, the position was that the applicant contended at trial he had purchased the fuel on or around the 15th of February at a petrol station. On the 21st of February, he put the cans in his car, intending to exchange it for firewood later, and went to his work. After the working day, he was stopped by the police on his way home. When stopped, he had not told about the purchase of the fuel because he felt intimidated and had no receipt to prove the purchase. So that was the basic background to the matter, Lords, in terms of the factual position. The Lords will see that so far as the submissions to the court were concerned, at paragraph 31 on page 8, that is under the heading Complaints concerning the pre-trial proceedings, it's argued that the applicant alleged that on the 21st of February 2001 he'd admitted the wrongdoing without the benefit of legal advice, fearing incarceration and in the hope of being acquitted at the trial. So that was his basic position advanced there. The Lords will see that the government submitted that the applicant's car had been inspected in the presence of 2 attesting witnesses. 2 cans of diesel had been seized from the car. As follows from the inspection record signed by the applicant, he'd poured out the diesel from his employer's premises. Thereafter, he'd been apprised of his right not to testify against himself and had been questioned under the relevant article of the Code of Criminal Procedure. The applicant confirmed he'd taken the diesel for personal use. The government contended that Article 47 had not been applicable in the record-based proceedings. The latter did not require the presence of counsel for an on-the-spot interview, such as that of the applicant on the 21st of February. In any event, the applicant waived his right not to testify against himself.
So the position was he wasn't in custody when this...
No, he was not. He was not taken to the police station. Or these statements against interest were made.
Yes.
First of all, in the course of discussions with the police, essentially at the roadside. Lords, on the merits, the court deals with the question of general principles again, as my Lords will see from paragraph 36. Paragraph 37, Saldus is again cited. But my Lords will see, and the Court also deals with the issue of waiver, but rather than taking up too much time going through those matters again, can I draw my Lord's attention to paragraph 42, first of all, on the page 11, application to the present case. First of all, Lord, the Court reiterates that in criminal matters, Article 6 of the Convention comes into play as soon as a person is charged. This may occur on a date prior to the case coming before the trial court, such as the date of arrest, the date when the person concerned was officially notified who would be prosecuted, or the date when preliminary investigations were opened. A charge for the purposes of Article 6.1 may be defined in the way that your Lordships are very familiar with, and it's set out there under reference to the leading authorities. And having done so, the Court continued, given the context of the road check and the applicant's inability to produce any proof of the diesel purchase at the moment of his questioning by the police, the Court considers that there should have been a suspicion of theft against the applicant at that moment. So that the Court appears to have taken the view there was a sufficient basis for suspicion in that context.
45.
And 45, as my Lord points out, that although the Court had accepted that Article 6 was applicable in the pre-trial proceedings in the present case, the Court repeats that the manner in which the guarantees of paragraphs 1 and 3c are to be applied in pre-trial proceedings depends on the special features of those proceedings and the circumstances of the case assessed in relation to the entirety of the domestic proceedings conducted in the case. And the Court then went on to consider the particular issue of legal assistance. Paragraph 46, the Court notes at the outset that the applicant only complained that he had not been afforded enough time to contact a lawyer in a nearby town. The Court cannot but note that, as confirmed by the applicant's representative in his letter to the European Court, both on the 21st of February and on the 2nd of March, the applicant chose not to exercise his right to legal representation with the hope that the Court would give him a fair trial, even without counsel. Moreover, the Court observes that the present case is different from previous cases concerning the right to legal assistance in pre-trial proceedings. And the Court then draws attention to Salbus and earlier cases. And having done so, continued on the next page, sorry, it's a little awkward, it's broken by the page, because the applicant was not formally arrested or interrogated in police custody. He was stopped for a road check. This check and the applicant's self-incriminating statements were both carried out and made in public in the presence of 2 attesting witnesses. It's true that the trial record contains a statement by the applicant suggesting that the writing down of the inspection record and or his subsequent statement were started on the spot, but were completed in a nearby village. Nevertheless, the Court concludes on the basis of the materials in the case file that the relevant events, namely the drawing of the inspection record and the taking of the applicant's explanation, were carried out in a direct sequence of events. Although the applicant in the present case was not free to leave, the Court considers that the circumstances of the case as presented by the parties and established by the Court disclose no significant curtailment of the applicant's freedom of action, which could be sufficient for activating a requirement for legal assistance already at this stage of the proceedings. So, my Lords can see that there's a line being maintained there. The Court...
Right. I didn't hear the comment.
I'm sorry, Lord. My fault. The Court can see that there's a line here that the European Court is drawing. That there is an indication that the circumstances were not such as to give rise to the activation of the right for legal assistance in those circumstances. So the Lords will see that the conclusion in paragraph 51 on this point in this case was, having set out these considerations, the foregoing considerations suffice for the Court to conclude that the absence of legal representation on the 21st of February and the 2nd of March did not violate the applicant's right to legal assistance under Article 6.3 of the Convention. The Court then did, however, go on to consider the privilege against self-incrimination and the right to remain silent in the subsequent paragraphs. And Lords will see that on the scope of that, there is reference at paragraph 54 to this point. Just mention it to your Lordships. I think it rose briefly this morning. Bearing in mind the concept of fairness in Article 6, the Court considers the right not to incriminate oneself cannot reasonably be confined to statements of admission of wrongdoing or to remarks which are directly incriminating. They refer back to the case of Saunders. Testimony obtained under compulsion which appears on its face to be of a non-incriminating nature, such as exculpatory remarks or mere information on questions of fact, may be later deployed in criminal proceedings in support of the prosecution case, for example, to contradict or cast doubt upon other statements of the accused or evidence given by him during the trial, or to otherwise undermine his credibility.
So it depends how they're used, really, doesn't it? If it's absolutely straightforward, gathering of information with a view to other inquiries, not actually going to be used against him at the trial, then it doesn't infringe the article. Is that,
Yes, no, the distinction might be drawn, to follow my Lord's question through, I think, between the function of the police conducting questioning under Section 14 for a variety of purposes, including the investigatory purpose that the Lord mentions, and the possible use of that material. So to develop the point slightly, Lord, if I may, the point the Lord made earlier about the practicalities of a solicitor being able to attend very promptly after detention. Lord, suppose a situation develops in which, for good reason, the police conduct an interview before the solicitor can attend, then the possible remedy, Lord, if these other contentions are soundly based, would be that the evidence could be declared to be inadmissible in a domestic context. So in other words, while the police, Lord, could derive a legitimate benefit in terms of investigation, the relevant convention rights could be maintained in a particular case by declaring the evidence inadmissible. The Lords will see that, although I think I didn't need to take up my Lord's time looking at the merits of this, that in particular the court did conclude that there had been a violation looked at more generally in respect of the right against self-incrimination, the right to silence. So even though there was a distinction drawn on the territory, nevertheless the circumstances described by the court still amounted to a violation.
and then at 65 we get this mysterious remedy reappearing.
Yes, absolutely. No, that's, again, I think a development of what was said by the Grand Chamber in Saldus and in the other cases Your Lordship's looking at before lunch. Lords, I also wanted, if I could, to draw attention to the case of Dayanan against Turkey, which is in Volume 4, tab 87. Lords, this
sorry,
tab,
which tab, please?
it's 87, Lord.
87.
And I should say, Lords, that the first report at tab 87 is in English. I understand it's a translation which has been commissioned to assist this court. The French version of the text is also at the same tab behind that, which is, for present purposes, the official report, as I understand it. But I seek to draw my Lord's attention to what's said in English in the hope that that will convey a sufficient flavour of the issue. Now, the Lords will see that the circumstances, facts are summarised, paragraphs 4, beginning at paragraphs 4 and following. The Lords will see, shortly put, he was arrested and taken into custody in January 2001 during an operation which he carried out against an illegal armed organisation. The applicant signed the form explaining the rights of arrested persons and examined the charges against him. He was advised of his right to remain silent and to speak to a lawyer when his custody ended. The police officers questioned him. The applicant availed himself of his right to remain silent. Paragraph 7 records, my Lords, that there was a search of his home conducted and an audio cassette taken, which may, from the State's point of view, thought to have been significant. And it's then recorded again at paragraph 8. During this time, the applicant remained silent. He was then remanded in custody, as my Lords will see, paragraph 9, and then a charge was brought by the public prosecutor, recorded in paragraph 10. And at 11, there was a first hearing in April 2001 before the State Security Court. He was then represented. He contested all charges against him. Regarding the audio cassette taken upon the search seized from his home, he stated that that belonged to his mother and he didn't know what it contained. At the hearing on the 29th of May, subsequent hearing, judges read aloud the depositions of 5 other people accused in other criminal proceedings relating to the same organisation, which named the applicant as being one of the members in charge of the organisation. They also presented the accused with seized documents concerning that organisation. The applicant's counsel maintained that the facts forming a basis for the infringement were not present. He stated the interested party had to be tried for assisting the illegal organisation on the basis of Article 169 of the Penal Code and not for belonging to this. He didn't call any witnesses. And Lords are then informed that further hearings occurred in 2001 and various additional submissions were advanced on his behalf. He was convicted, it's recorded at paragraph 15, and sentenced to 12.5 years imprisonment. Paragraph 16 records that the court based its decision on the reports and the documents in the court file. In particular, it took into account the witness statements naming the applicant as one of the members in charge of the organisation. It also based its decision on a document showing the applicant's place within the organisation. In particular, it considered to have been established that the applicant was an active member of the incriminated organisation. He then, through his lawyer, gave notice of intention to appeal against that decision, and the Chief Prosecutor filed written submissions which were not intimated to the applicant or his lawyer in reflection of what had occurred in Saldus, and the court followed that matter through. At paragraph 21, there's reference to the principles in Saldus, as your Lordships will see referred to. The court then went on to consider the law. Invoking Article 6.1 and 6.3 of the Convention, the applicant complains of not having received legal assistance during his custody and not having been notified of the written observations of the Chief Public Prosecutor. The government invokes as defence failure to comply with the 6-month limit, which the court then deals with and puts to one side. My Lords will see that on the first point about the Public Prosecutor's submissions, the court dealt with that at paragraph 25. At paragraph 28, or perhaps I should take the matter up at 27, Lord. With regard to non-exhaustion of national means of redress, the court observes that the applicant's right to the assistance of a lawyer was restricted while he was in custody, in accordance with domestic law, on the grounds he was accused of a crime coming under the jurisdiction of the state security courts. Moreover, it notes that the practice of not notifying the Chief Public Prosecutor's written observations was also in keeping with the law in force. The court notes that the applicant's objections based on Article 6.1 and 6.3c of the Convention are manifestly unfounded. Regarding the merits of the case, 29, the government notes that the applicant made use of his right to remain silent while in custody, so the absence of a lawyer had no impact on respect for his rights of defence. As for the objection regarding failure to notify him of the written observations, the government refers to the comments in the earlier Turkish case. With regard to the absence of the lawyer whilst in custody, the court draws attention to the fact that the right of any accused person to be effectively defended by a lawyer, if necessary, appointed by the courts, is one of the fundamental elements of a fair trial, referring to Saldus and others. It considers that in general, for the purposes of Article 6 of the Convention, a fair criminal trial requires the suspect to have the possibility of legal assistance when placed in custody or on remand. As stressed by generally accepted international practices which the court accepts and which frame its jurisprudence, as soon as he is deprived of his freedom, an accused person have access to a lawyer regardless of the questioning he undergoes. Indeed, a fair trial requires that the accused have access to the full range of services provided by the lawyer. In this regard, discussion of the case, organisation of the defence, the quest for evidence in favour of the accused, preparation for questioning, support for an accused person in distress, and monitoring of the conditions of detention are fundamental elements of the defence that must be freely exercised by the lawyer. In this case, the fact that the applicant did not have legal assistance while in custody is not contested at all, because legislation in force at the relevant time precluded this. In itself, such a systemic restriction based on relevant legal provisions suffices in order to conclude that the requirements of Article 6 of the Convention were violated, notwithstanding the fact that the applicant remained silent while in custody. Therefore, the court concludes that Article 6.3 of the Convention plus Article 6 were violated. And the court then went on to deal with the second point and made the findings which it did. Now, it may be, Lords, and I appreciate that this is in translation, but I thought it right to draw it to your Lordship's attention because there are obviously at least two ways that the court might look at the matter, Lords. The first is that it might be seen as a development of the principles in Saldus, even when an applicant exercises his right to remain silent and does so, there may yet be a violation. And if so, my lords, in my respectful submission, that reaches back to the court, the Grand Chamber's concern in Saldus that this was a systemic restriction on the right of access.
And that's what they're saying in 33, isn't it?
Yes, on the face of it, it is, my lord.
It's just the same language as we saw elsewhere.
Yes, indeed.
And the result of that is what? That every Scottish conviction under this systemic process fails as a miscarriage of justice. And what's the submission?
Well, on the face of it, my lord, that's the more austere reading of this case.
But is that your submission?
No, my lord, not.
Oh, well, what is your submission?
My submission, my lord, rests on Saldus, but what I invite my lords to take from this case is a recognition, as I think my lords saw in the dissenting judgment of Judge Bratza in Saldus, that concurring judgment, that Judge Bratza was envisaging that a lawyer's function is more significant than simply advising on the right to silence, and suggesting that the majority had perhaps not expressed that matter as clearly as his lordship would have wished. So it may be that this case is more concerned with the fact that there was a deprivation of a lawyer in respect of these other features for which a lawyer's assistance is normally required and summarised at paragraph 32.
I think it plainly was, because in this case he had remained silent. But surely your answer to my Lord, Lord Brown, is that you don't have to go further than the essence of Saldus, which is to the effect that where there has been an incriminatory statement made without the benefit of legal advice, and where that statement is used in the prosecution of the defendant, then that will render the trial unfair.
Absolutely, Lord. I'm very obliged. That's as far as I need to go, Lord.
On one view, De Anan is a logical extension of it, because a lawyer's services may go well beyond simply telling his client to be quiet. On occasions, it may be that well-crafted advice will be to make admissions or to make statements. So it's logical, on one view, that if you're deprived of those services, that the consequence may be the same. But essentially, you don't need to rely on this case at all, do you?
No, I don't, Lord.
Why are we looking at it then?
Well, might I suggest that it is of interest to the Lord Advocate, because, you see, the result of this case could be one or other of two things. Either it's narrowly focused on a situation where the applicant did not remain silent, and where evidence or admissions or whatever it is obtained without a lawyer being present are used against him at the trial. Now, there could be a subset within that, cases where it didn't actually affect the outcome at all, in which case one might say it actually didn't result in a violation, looking at all the circumstances. But the basic position is, if it's that, the Lord Advocate would look at the cases where that actually occurred. But if this case suggests it reaches very much further, and it's just wherever the system is used. So, you may not need to press it that far, but if we're to see what the consequences of the argument are, it looks as though it doesn't have a stopping point at where you're suggesting it stops.
Well, not necessarily, my Lord. I draw it to my Lord's attention because I think it's right the court see the possible development of the matter. But as my Lord Kerr helpfully pointed out, for the purposes of the argument for the appellant, Lords, I don't need to go further than the way in which my Lord Kerr assisted in formulating the matter a moment or so ago. For the purposes of the appellant, that's the core principle of Saldus, and that's sufficient for the appellant's purposes.
But what are the consequences for the Lord Advocate? Suppose the Lord Advocate is faced with someone who remains silent and who then at trial says, but I wasn't given a lawyer during the 6 years, I was deprived of the opportunity of discussion and organisation of my defence, etc., etc., etc. And is Lord Advocate then able to say, well, you show that that's got some conceivable relevance. I would imagine that's the first thing the Lord Advocate would say, and it would be, maybe there would be a technical breach, but again, you wouldn't establish a miscarriage of justice. Why the Court of Justice leaps automatically to a conclusion that there ought to be a retrial, I'm not sure. Does it do that in this case?
No, I don't think so.
It doesn't. No, well, then that's different. That may be rather important, because one certainly wouldn't leap automatically to that conclusion.
But in reality, the situation we're dealing with is only the period of detention, isn't it? Because
Yes.
in practice in Scotland, you will get legal assistance at your trial, and it will be available from the moment of arrest.
Yes.
And no question of being questioned once you've been arrested. So we're looking at a very narrow 6-hour period.
Yes.
But within it, there are those categories of cases where the person remains silent, but you would say, you were pointing anyway to paragraph 33, last sentence, which rather suggests that the system is so defective that that itself means that everybody who's been subjected to that without a solicitor being present is able to claim that there's been a violation. You don't need to go so far, but the Lord Advocate has to be aware that it might be taken that far.
Yes, absolutely. No. I'm respectfully drawing that to the Court's attention because it may be thought to be a development, and really just assist the lawyers to see that that could be one way of viewing it, but the argument of the appellant doesn't depend on that.
But it is significant that the Court here didn't find a causal nexus between the violations and the material damage alleged. See paragraph 41. Material alleged is that presumably contained in paragraph 37. So, as Lord Mance points out, it doesn't follow that because there has been a technical failure to provide legal representation, that it has the consequence of disadvantage to the applicant in the way that is outlined here.
Absolutely not. Certainly, if when we're imagining the context of a conventional appeal against conviction in Scotland, the first thing that the Lord Advocate would no doubt say is exactly as my Lord Mance has indicated. The appellant would have to point to some palpable prejudice in order to demonstrate there'd been a miscarriage of justice. So, in my submission, this case doesn't necessarily cause, with respect to your Lordships, any particular difficulty with the basic argument, but I just thought I should draw that to the Court's attention. It also appears potentially, Mills, to be a development of the observations of Judge Bratzer in his opinion. Yes. And I think in addition, Judge Zagrabelski, which I think your Lordship saw in the report of the decision in the Grand Chamber. I should also say, my Lords, that this case has been referred to at least twice, my Lords. First in Pavlenko, which I've mentioned to your Lordships. I just give my Lords, I think it's paragraph 97 on this point. And in a case called Savas, at volume 6, tab 147, at paragraph 70.
70?
70, yes.
And the Pavlenko paragraph was 119.
It's 97, 97 Lord. There were two references, Lord, to Pavlenko. This is the second of the two, and it's 97.
Thank you.
So do you want us to look at Pavlenko?
No, my Lord, I didn't want to take up time. Just give my Lord the reference to that, just to say it's been cited in that. My Lords will be aware particularly from the helpful information laid before the Court by the intervener, that matters have been looked at in different European jurisdictions since the decision in Saldo's, my Lords. I didn't wish to take up too much time dealing with that, my Lords, but I wonder if I might draw attention briefly to what the Dutch Supreme Court has said about the matter, my Lords. This is in volume 7 at tab 165.
So far in the Strasbourg Court cases, we've been lurking rather around the fringes of Eastern Europe. Is there much that one finds in the Western area?
Lord, in the frightening footnote that has been prepared for the appellant's case, Lord, there is reference to a Swedish and a German case, amongst others.
Yes.
Lord, where Saldo's is referred to without any adverse comment, although the contexts are different. Well, I think in neither of those cases was there ultimately a violation. The circumstances were different.
I think domestically, I think is it the intervener who gives us a good deal of information about discussion in particular in France, but other countries as well,
Yes.
where there's a great consciousness that the procedure of garde à vue is very vulnerable.
Well, I'm obliged, my Lord, to my learned friend Mr O'Neill, because he's set that matter out in the written case of the intervener, my Lord, drawing attention to the approach of the French court, so far at least, in wake of Saldus. And I had, for my part, my Lord, not intended to take up time going through that, my Lord, but recognising that your Lordships may derive some assistance from it.
So which tab are we in volume 7 for Holland?
165, it should be, I hope, my Lord.
Presumably edited highlights of this.
Well, Lord, my understanding is that what has gone before is that the Advocate General has produced a very lengthy opinion, and that this
Snappy summary, is it?
I'm sorry, Lord.
It's a snappy summary.
Yes, this is the court's. Effectively, this is the court's conclusion, Lord, in, as my Lord says, in snappy summary. It's the whole thing on this thing. It's the beginning, isn't it? Well, Lords, I should say that in this particular tab, the physical reproduction, Lord, I think has 3 cases that were conjoined. Lord,
That may explain why the paragraph numbering is otherwise incomprehensible.
well, Lord, I hope that I could, by not wishing to avoid your Lordship's question too much, deal with it in a relatively snappy summary form of way, because if my Lords have the first page of the tab, there's reference to the Supreme Court at the top, and in the left-hand corner the case reference, and the date of the judgment is the 30th of June 2009. If my Lords would be kind enough to turn to the next page, my Lord will see again at the top left-hand corner a reference to the judgment and the date of the 30th of June 2009 in the Criminal Division. And my Lords will see that the background to it is a ruling on appeal in cassation against a ruling of the Hague Court of Appeal of the 18th of April 2008 in the criminal case of, and there are 3 cases drawn together, and they're dealt with one after the other in this tab.
2.1, it's obviously looking at Saldus then.
Yes, absolutely, Lord. And the court is looking at Saldus. And then, my Lords will see on the opposite page at 2.3.2, this opinion is based in particular on the following considerations. And the court, and then what is set out are the paragraphs from Saldus starting at 50 and moving through onto the following page to 55 and then 59, which your Lordships have already seen. Now, the Lords will see then thereafter at paragraph 2.4, preparing a general legal assistance rule in relation to the police interview goes beyond, partly in view of the policy-related organisational and financial aspects, the law-forming remit of the Supreme Court. Nevertheless, the case law of the European Court of Human Rights raises questions which the criminal court judge will have to answer as the occasion arises. To that end, I make the following observations. The Supreme Court infers from the case law that a suspect who is arrested by the police may base a claim to legal assistance on Article 6, which entails his being offered the opportunity to consult a lawyer prior to being interviewed by the police about his involvement in a criminal offence. However, it cannot be concluded from the case law of the European Court of Human Rights that the suspect is entitled to have a lawyer present during police interview. This, I think, is a point my Lord Walker raised with me this morning.
Is that a correct translation?
Well, I hope so, my Lord, but I must admit I haven't independently applied myself to whether it is. The matter continues this way, my Lords. The above considerations imply that the accused suspect should be advised of his right to consult a lawyer before the first interview commences, unless he's expressly or tacitly, but in any case unequivocally waived that right, or there are compelling reasons as referred to by the Court of Human Rights. He must be offered the opportunity to exercise that right within the bounds of reasonableness. The above pertains both to adults who have been arrested under criminal law and to juveniles who have been arrested under criminal law. The fact that arrested juvenile suspects are also entitled to be assisted by a lawyer or another person of trust during the interview by police is worthy of note. If a suspect in custody is not offered the opportunity to consult a lawyer prior to first interview by police, or is not offered an opportunity within the bounds of reasonableness, this in principle constitutes non-compliance with the procedural requirements as referred to in the Code of Criminal Procedure. Having regard to the interpretation given to this provision, the judge, if a defence is advanced to this effect, must assess whether any legal consequences should be attached to an omission, and if this is the case, which legal consequence qualifies. He should also take into account the factors specified in paragraph 2 of Article 359 of the Code of Criminal Procedure. The legal consequence will, after all, have to be justified by these factors. One of these factors is the seriousness of the omission. On the basis of the case law of the European Court, it must be assumed that in cases such as these, an important regulation pertaining to criminal law or a legal principle has been violated. Therefore, and under consideration of the finding of the Court, paragraph 55, after a defence argument to that effect, the non-compliance with procedural requirements described in 2.7 should generally, i.e. apart from which is that which has been considered above in relation to the suspect's waiver of the right to consult a lawyer and the compelling reasons referred to by the European Court, lead to the statements made by the suspect before he was able to consult a lawyer being excluded from the evidence. It should be pointed out that the above also applies to a defence which relates to evidence which has been obtained as a direct result of a statement which cannot be used as evidence as referred to above. There is no answer in a general sense as to what constitutes a direct result, albeit a statement, which the suspect has made subsequently after he has been able to consult a lawyer and has been notified in accordance with Article 29.2 of the Code of Criminal Procedure that he is not obliged to answer, does not in principle qualify for exclusion of the evidence. It's also worth pointing out that the suspect has no interest in a discussion of his defence to the effect that evidence should be excluded if the material with regard to which an appeal has been made for evidence to be excluded has not been used by the court as evidence. So I draw that to my Lord's attention because it obviously picks out some of the themes that your Lordships have been considering, drawing a distinction in this context between the right of access to a lawyer in the form of a consultation before interview, but not extending to the lawyer being present during the interview, and that the general consequence appears to be, from a domestic point of view, the exclusion of evidence if there's been a deprivation of access.
Is 2.7.3, is this the fruit of the poison tree? Isn't this the sort of thing? You can't bring in evidence which you have. The prosecution can't bring in evidence which it has generated as a result of a statement obtained without the person. Yes. Is that what we're talking about?
That's my understanding, Lord. But the Lord will see that 2.73, which I read, Lord, is it differs from one reading of Diane Ann by saying that there's no paraphrase, Lord, there's no complaint if the material is not used. So, in a sense, my Lords, I cite it because it suggests perhaps how the domestic courts in this country might deal with similar sorts of considerations, depending on the view that my Lords came to as to the meaning of Saldus itself.
I mean, this leads to the kind of thing where somebody makes an admission before he gets the says something before he gets the legal advice, says there's a body buried in that field. The police go along and get the body and find things which correspond to his, let's say they found his DNA on the body or something like that. Would all that be excluded?
Well, on this approach, Lord, it might be, but then...
Sounds terribly drastic.
It has to be said, though, Lord, if that is the drastic consequences, it appears to be one that commends itself to the Dutch Supreme Court. It needn't be the consequence in other jurisdictions, more than non-respectful submission. It depends on the circumstances.
And the only let out in paragraph 2.7.2 is either waiver, which is carefully circumscribed, of course, or compelling reasons, whatever they might be.
That's true, my Lord, but this is an interpretation of Saldus by the Dutch Supreme Court, and the point my Lord Roger was raising would not necessarily follow in every other, the point of view of every other Supreme Court necessarily, and it doesn't derive directly from Saldus, that particular point.
Well, the second sentence of 2.5, first paragraph, is very puzzling in view of what follows, because it does seem to assume that the suspect is entitled to have a lawyer present.
Well, My Lord, I'm sorry, it's probably, I probably read it badly, my Lord. I had understood the Supreme Court to say that what flows from SALDUs is that one has the opportunity to consult, but what does not flow from it is that the lawyer has to be present at the interview. And that's what I'd understood that the court was seeking to reflect in paragraph 2.5, my Lord, in those two.
Right, I see. So he's offered the opportunity. If he turns it down, waives it, then...
No, I'm sorry, my Lord, it's my fault. I've explained it badly, my Lord. Paragraph 2.5, if I could just ask my Lord to look at that again. The Supreme Court infers from the case law that a suspect who is arrested by the police may base a claim to legal assistance on Article 6, which entails his being offered the opportunity to consult a lawyer prior to being interviewed by the police about his involvement.
They're accepting the Advocate General's advice. If you look after this judgment, it's followed by Mr. Knigge. And if one goes to paragraph 7.12 of his advice, he distinguishes between pre-interview consultation, which he says is the essence of the case, not the physical presence of a defence counsel during the police interview.
Absolutely,
Yes, I see. So present is the...
Yeah.
Yes, thank you very much. Yes.
Lord, perhaps I should just clarify that a juvenile has the right, in addition, Lord, to have a lawyer present during the interview. But as far as adults are concerned, the distinction that my Lord Mann draws is the one reflected in the judgment.
Yes. Right.
Now, my Lords, in my respectful submission, what your Lordships may take from the cases referred to in the footnote and the ones I've drawn your Lordship's attention to, in my respectful submission, is a clear exposition of the principles in SALDUs, and in my submission, your Lordships find those principles being applied regularly in the decisions that have come afterwards. And, of course, my Lords, I respectfully submit that that's of significance because one of the matters which my Lords will appreciate was raised before the High Court of Justiciary in the case of McLean was whether, under Section 2.1 of the Human Rights Act, your Lordships ought to follow the decision of the Grand Chamber if the contention advanced for the appellant so far is broadly sound. And for reasons which I've sought to set out in the printed case, my Lords, and would seek to briefly summarise, I would invite my Lords to reach the view, if that is a question for the Court to determine, that the Court should follow the Grand Chamber decision. And very briefly, my Lords, the first point is that the decision in my submission contains statements of principle which have been cited and applied in a number of subsequent cases. And in its exposition of those principles, in particular the right of access, did not depend on a detailed understanding of the systems of contracting states, and I would also submit to my Lords, as I've touched on briefly, that the decision can be seen as representing a natural development of principles which have been earlier articulated by the Court. Lords, I earlier mentioned the case of Murray against the United Kingdom. Perhaps I could just take Lords briefly to that. It's volume 5, tab 126. Lords, just reminding the Lords very briefly of the context. At the first page of the report, page 29, the applicant was found guilty of aiding and abetting unlawful imprisonment and sentenced to 8 years in prison. He had been arrested on the 7th of January 1990 under the Prevention of Terrorism Temporary Provisions Act of 1989. Following arrest, he was cautioned under the Criminal Evidence Northern Ireland Order of 1988 and informed that adverse inferences could be drawn at his trial if he elected to remain silent and not answer police questions. He was also denied legal advice for 48 hours. On finding the applicant guilty, the judge informed him that he had drawn adverse inferences from the fact that he had not answered police questions and he had not given evidence at his trial. In his application to the Commission, the applicant complained that the denial of legal advice for 48 hours and the fact that inferences were drawn had resulted in him not having a fair trial under Article 6. He also claimed that he was discriminated against under Article 14. It was held by the court that by 14 votes to 5 there had been no violation of Article 6.1 and 6.2 of the Convention arising out of the drawing of adverse inferences on account of the applicant's silence, but by 12 votes to 7 that there had been a violation of Article 6.1 in conjunction with 3C of the Convention as regards the applicant's lack of access to a lawyer during the first 48 hours of his police detention. Lords, it's a relatively lengthy report, but the judgment of the court in this report starts at page 57. And there, Lords, without repeating it, Article 6.3c is set out at paragraph 40. Paragraph 41, the court goes on to consider Article 6.1 and 6.2 and the right to silence. The Lords will see, in passing, if I may just draw attention to this, page 58 at the end of the second paragraph, that part of the applicant's submission to the court was that the right to remain silent was an absolute right which he was entitled to enjoy without restriction. My Lords will see that the court turned to deal with that part of the argument at paragraph 46 and 47. And having looked at that matter, Lords, 47, the court said, on the one hand, it's self-evident that it's incompatible with the immunities under consideration to base a conviction solely or mainly on the accused's silence or on a refusal to answer questions or to give evidence himself. On the other hand, the court deems it equally obvious that these immunities cannot and should not prevent that the accused's silence in situations which clearly call for an explanation from him be taken into account in assessing the persuasiveness of the evidence adduced by the prosecution. Wherever the line between these two extremes is to be drawn, it follows from this understanding of the right to silence that the question whether the right is absolute must be answered in the negative. So the court rejected at least that argument, Lords. The Lords will see that when the court went on further on at page 64 and following to deal with the arguments in respect of access to a lawyer, again, in reflection on the points my Lords have earlier raised, at paragraph 60, I just mentioned to your Lordships that it's recorded there that in submission of the government, actual as opposed to notional or theoretical prejudice must be shown by an applicant in order to conclude that there had been a breach of Article 6.1.
Sorry, where do we find that?
Paragraph 60, Lords, at page 65. Okay. And again, Lords, not to take up time, if my Lords would be kind enough to look at the fruit of paragraph 60, again, as a rehearsal of the government's submission, last sentence. In order to make out a case of actual prejudice, it must be alleged by the applicant that if he'd been able to consult his solicitor earlier, he would have acted differently. So that's part of the argument that the government advanced. The Lords will then see, looking on to page 66, that's in paragraph 63, and again, this is just to give your Lordship some context for the point that my Lord and the Chair raised earlier. The court says, national laws may attach consequences to the attitude of an accused at the initial stages of police interrogation, which are decisive for the prospects of the defence in any subsequent criminal proceedings, and so on. So my Lords will see that this is the exposition of this principle, paragraph 63, that your Lordships have seen reproduced in the other cases. My Lords will then see at 64, it's recorded the applicant's right of access to a lawyer during the first 48 hours of police detention was restricted under the relevant Act on the basis that the police had reasonable grounds to believe the exercise of the right of access would, inter alia, interfere with the gathering of information about the commission of acts of terrorism or make it more difficult to prevent such an act. It is observed that the applicant did not seek to challenge the exercise of this power by instituting proceedings for judicial review, although before the court he now contests its lawfulness. The court, however, has no reason to doubt that it amounted to a lawful exercise of the power to restrict access. Nevertheless, although it's an important element to be taken into account, even a lawfully exercised power of restriction is capable of depriving an accused in certain circumstances of a fair procedure. And again, my Lords, we saw the reflection of that in the quotations from this judgment that my Lords see in Saldus. Of course, my Lords, the case of Murray, at least in the appellant's submission, is a case in which the court was satisfied that there was a lawful basis for restricting right of access, so it's a different case to the situation in Saldus. And the court then said at 66, the court is of the opinion that the scheme contained in the order is such that it's of paramount importance for the rights of the defence that the accused has access to a lawyer at the initial stages of police interrogation. It observes in this context that under the order, at the beginning of police interrogation, an accused is confronted with a fundamental dilemma relating to his defence, and the court then goes on to explain its reasons for saying so. And then, having done so, there's reference to the rights of the defence may well be irretrievably prejudiced, whatever the justification for such denial in a way that's incompatible with the rights under Article 6. So again, another of the linguistic themes and principles your Lordships have seen set out in Saldus. My Lords will also see that on the question of whether the court should speculate as to what would have happened if there had been access, my Lords, the government having made that argument, at paragraph 68, my Lords will see it's true, as pointed out by the government, that when the applicant was able to consult with his solicitor, he was advised to continue to remain silent, and that during the trial the applicant chose not to give evidence or call witnesses on his behalf. However, it's not for the court to speculate on what the applicant's reaction or his lawyer's advice would have been had access not been denied during this initial period. As matters stand, the applicant was undoubtedly directly affected by the denial of access and the ensuing interference with the rights of the defence. The court's conclusion as to the drawing of inferences does not alter that. And then the court went on to find a violation on that basis. So, Lords, I cite that because I've mentioned it, Lords, in the context of this branch of the argument, to say to Lords that many of the principles that Lordship see cited in Saldus come from Murray. But the case was the context of the case of Murray and the other cases was different, in my respectful submission. So while I recognise, Lords, there is plainly a development in the Grand Chamber decision, in my submission it is, in the context of the Convention being treated as a living instrument, a natural development of these principles. And there is, in my respectful submission, both from the Murray case, Lords, and subsequently, no suggestion that the right of access, which is itself implied into Article 6.3, is being characterised by the European Court as absolute.
So you got 15,000 for this?
Yes.
Paragraph 79. Less out French francs.
Lords, perhaps I should just remind my Lords, if I could, in passing, that the decision of the Grand Chamber was a unanimous one in Saldus. And my Lords, in this connection, as to whether my Lords ought to follow the Grand Chamber decision, I'd also respectfully submit to my Lords that there's no obvious flaw in the reasoning of the Grand Chamber which raised doubts of the kind that were articulated by the Judicial Committee of the Privy Council in Brown against Stott in discussing the earlier decision of the European Court in the case of Saunders.
Do we get any hint from Horncastle as to what our attitude should be?
Yes, in my respectful submission, there is some value to be gained from that, Lord. I think the observations that this court made in Horncastle's at Volume 3, tab 49.
Volume what?
Volume 3, my Lord, tab 49. The Lords, I'm sure, will be very familiar with the context. The judgment was delivered by Lord Phillips. The Lords will find that judgment beginning at page 95. The Lords, on the approach to the appeal, His Lordship deals with that starting at paragraph 9.
Is that paragraph?
9, Lord, on page 96 of this report. The Lords will see that it's there recorded. Article 43(1) of the Convention provides that within a period of 3 months from the date of the judgment in the Chamber, any party may, in an exceptional case, request that the case be referred to the Grand Chamber. Article 43(2) provides that a panel of 5 judges of the Grand Chamber shall accept the request if the case raises a serious question affecting the interpretation or application of the Convention or its protocols, or a serious issue of general importance. On the 16th of April 2009, the United Kingdom requested that the decision of the Chamber in Al-Khawaja be referred to the Grand Chamber. On the 5th of June, the panel of the Grand Chamber adjourned consideration of that request pending our judgment in the present case. Mr Owen for Mr Horncastle and Mr Blackmore submitted that we should treat the judgment of the Chamber in Al-Khawaja as determinative of the success of these appeals. He submitted that this was the appropriate response to the requirement of Section 2(1) of the Human Rights Act that requires a court to take into account any judgment of the European Court of Human Rights in determining any question to which such judgment is relevant. He submitted that the decision of the House of Lords and the Secretary of State for the Home Department against AF exemplified the correct approach to the decision of the European Court. In that case, the committee held itself bound to apply a clear statement of principle by the Grand Chamber in respect to the precise issue that was before the committee. Mr Owen submitted that we should adopt precisely the same approach to the decision of the Chamber in Al-Khawaja. I do not accept that submission. The requirement to take into account the Strasbourg jurisprudence will normally result in the domestic court applying principles that are clearly established by the Strasbourg court. There will, however, be rare occasions where the domestic court has concerns as to whether a decision of the Strasbourg court sufficiently appreciates or accommodates particular aspects of our domestic process. In such circumstances, it's open to the domestic courts to decline to follow the Strasbourg decision, giving reasons for adopting this course. This is likely to give the Strasbourg court the opportunity to reconsider the particular aspect of the decision that is in issue, so that there takes place what may prove to be a valuable dialogue between the domestic court and the Strasbourg court. This is such a case. Now, so far as that is concerned, Lord, respectfully, it seems that this court was indicating that it will be on rare occasions when the domestic court has particular concerns of the kind articulated by Lord Phillips, that the court will decline to follow a decision of the Grand Chamber.
I think I looked at the same issue at paragraphs 117 to 120.
Yes, thank you, Lord.
I don't think it's worth spending a lot of time on that. I'm going to point it out.
Could we have the page number, because there's an appendix
It's the
here.
last 2 pages.
Is it? Oh, so it is, 'cause there's an appendix in between, isn't there?
Yeah.
So which paragraphs are we?
That's page 151.
117 to 120. The quotation from Lord Roger at 118.
Yes.
As I understand it, in 118, the Lord was making a clear distinction between the case of Horncastle and the case of AF.
Quite.
You say we're near AF, is that right?
Yes, Lord. I don't suppose it will surprise your Lordship to hear me say that on behalf of the appellant, but in my submission, it is closer to that, Lord. In my respectful submission, what the Grand Chamber was concerned with in Saldo's was exposition of principles, and those principles having, in my submission, been clearly explained, then your Lordship should take the normal approach, in my respectful submission, and follow the decision of the Grand Chamber.
And of course it's Grand Chamber unanimous, as you said.
Yes, indeed it is, my Lord. And as my Lords will be well aware of the observations made principally in the House of Lords previously, my Lords, if I could just remind my Lordship, your Lordships, without necessarily going into the detail, but, Lord, in the case of Anderson, which will be familiar to your Lordships, there's the observations of Lord Bingham of Cornhill at paragraph 18. Lords, that's to be found at volume 2 at tab 44 on page 879 of the report.
Which paragraph?
Was it before?
It's paragraph 18, my Lord.
1-8.
1-8, my Lord, at 879
Yes,
of this
yes.
report. Lords, it's to this effect. It was argued for the Home Secretary that the House should not follow this judgment, which was criticised as erroneous and lacking in reasoning to justify and explain the Court's departure from its previous ruling. I cannot accept this argument. While the duty of the House under Section 21A of the Human Rights Act is to take into account any judgment of the European Court, whose judgments are not strictly binding, the House will not without good reason depart from the principles laid down in a carefully considered judgment of the Court sitting as a Grand Chamber. His Lordship refers to Alconbury.
So which paragraph is it again, please?
18, Lord.
18.
18 on page 879 of that report.
Oh, 879.
Yes.
I don't think it's being said that the reasoning in Saldus is wrong or lacking or erroneous. I think it's more being said that it's not appropriate to apply it to Scotland for a whole host of reasons which are set out in the printed case.
Yes.
What do you say about that?
Well, I say, Lord, with respect, that if it can be accepted that the Grand Chamber is explaining the principle, Lord, it's a fundamental feature of the scheme of protection of Article 6. In my respectful submission, it should be followed because what the Court is doing is explaining that it's a fundamental feature of the protections provided by Article 6.3 and Article 6.1. And if it be the position, Lord, that the present circumstances in Scotland are out of step with most of the other jurisdictions, then so be it, Lord, is my submission. The principles are clearly enough explained, and as my Lords have explained in a series of these decisions, your Lordships would generally find it appropriate to follow the guidance of the Grand Chamber. Lords, Lord Bingham had returned to theme to supplement these observations in the case of Ulla, which I should also mention to your Lordships briefly, if I could. It's volume 3, tab 53.
Well, we're very, very familiar with Ulla. I think we know.
I'm sure it needn't be repeated then, Lords. It's paragraph 20.
And
Yes.
Lord Brown has a little codicil as well.
He does.
Yes, indeed.
Well, we've had enough of our Scania again.
There are certain differences of emphasis, as I understand it, between my Lord Brown and Lord Bingham of Cornhill. So then that takes your Lordships to the point in Horncastle, where the Court has observed it would only be in rare occasions that your Lordships would not follow the matter. And then, as my Lord Rogers helped to draw out, I also rely on AF and my Lord's observation at paragraph 98 and the observations of Lord Hoffman at paragraph 70. And my Lords will find that if, again, those passages need to be pointed out again to my Lords in any way, it's volume 3, tab 60.
Paragraph numbers again.
Lord Hoffman, Lord, at paragraph 70, and my Lord Roger at paragraph 98. So I'm obliged, my Lord. I wonder if I could turn briefly then to ask my Lords to apply what I say the principles of Saldus are to the present case.
Yes. Do we go to Maclean or do we go to
Perhaps I could, in answer to my Lord's question, perhaps I could take the matter this way so far as Maclean is concerned, my Lord. In the printed case for the appellant, I respectfully submit to your Lordships in writing reasons why the High Court was in error in its approach in Maclean.
paragraphs?
Paragraph starting at 411, Lord.
Paragraph 4.
411, Lord, in the case for the appellant, which is at page 14.
Yeah. And do we pay any attention, any regard to the fact this is a 7-judge decision, unusually large court?
Well, Lord, no doubt any decision of the High Court Justicia composed of 7 judges is one worthy of respect. But the Lords will appreciate that in the first instance the court was convened as a bench of 7 because of the earlier case of Peyton and Ritchie had been followed by a bench of 5 judges in the subsequent case of Dixon. Lord, the bench of 5 judges had been convened in Dixon for a different reason. So, on one view, the court in Dixon was merely following what the court of 3 judges had earlier said in Peyton against Ritchie. But that's just a brief exposition of how it came to be, Lord, that 7 judges were convened in the case of Maclean. My Lords, there were basically 2 matters, 2 principal conclusions of the court in Maclean, as my Lords will be aware. The court applied its judgment first to whether paragraph 55...
I think we should perhaps look at it. Just
Yes, of course.
where do we find it?
It's in volume 2, my Lords, at tab 36.
26, 36.
36, my Lord. Lords, this is the report from the Scots Law Times. If I can take my Lords to page 82, which is the discussion section of the opinion of the court delivered by Lord Justice General. At paragraph 23, His Lordship refers to the case of Saldus and sets out reference to it. And having done so, Lords will see that just below letter D, the court continued, the right under Article 6.3c is, like that under 6.3d, a minimum right, but in contrast to the right under Article 6.1 is not an absolute right. While in some circumstances it may be relevant to ask whether there's been a violation of Article 6.3c in isolation, the relevant question in the present case is whether the circumstance that the Minister did not have access to a solicitor prior to being interviewed by the police would render unfair any trial on which reliance is placed by the prosecutor on his responses during that interview. The critical issue is thus whether there's a prospective violation of Article 6.1. I just remind my Lords that the matter came before the court by way of the reference procedure under the Scotland Act in advance of any determination of guilt. There had been no trial at that stage. A devolution minute had been raised in the Sheriff Court, and the Sheriff had made a reference under the Scotland Act to the High Court. The Lords will then see that paragraph 24, the first sentence of paragraph 55 of the Grand Chamber's judgment, Saldus is open to interpretation, The court finds that Article 6.1 requires that, as a rule, access to a lawyer should be provided unless it's demonstrated in light of the particular circumstances of each case that there are compelling reasons to restrict this right. Thus, the requirement is subject to exception where such particular demonstration is made. Additionally, the requirement applies only as a rule. On one reading, the sentence may import that the court is laying down that every jurisdiction must, to be compliant with the Convention, have in place a system under which such access is ordinarily provided, as from the first interrogation, whatever safeguards there may otherwise be for a fair trial. Alternatively, the court may, while indicating what it would generally expect, be recognising that the issue as to whether or not there has been a fair trial would depend on the particular circumstances of the case, including what arrangements the jurisdiction in question has made for access to legal advice, seen against the guarantees which are otherwise in place in that jurisdiction to secure a fair trial. Neither the phrase "as a rule" nor the French version gives any clear pointer to which interpretation is to be preferred, nor does the phrase "in principle" in the final sentence of the paragraph assist. As, however, that final sentence makes plain, the issue for decision in Saldus was whether incriminating statements made in certain circumstances irretrievably prejudiced the rights of the defence. That issue could be reformulated as whether such statements, if admitted at the trial, would irretrievably prejudice such rights. The court has consistently taken the view that questions of the admissibility of evidence are principally matters for domestic courts, that the court also found it appropriate to discuss paragraph 56 and following the application of the general principles to the case before it, rather than holding that lack of access to a lawyer ipso facto led to a violation, may also suggest that certain flexibility in the application of the requirement was being recognised. We are inclined to favour the alternative interpretation. Were that not what the court intended, it would, in our view, be departing from, or at least substantially developing, its prior case law. Judge Bratza, in his concurring opinion, expressly says that the principle being enunciated is consistent with the court's earlier case law. In Murray against the United Kingdom, the decision, it seems, turned upon the inferences which could be drawn from the silence of the detainee. In Brennan, the court was not persuaded that the attendance of the suspect's lawyer during police questioning was an indispensable precondition of fairness within the meaning of Article 6. If lack of access to a lawyer and subsequent use of incriminating statements were themselves to be regarded as giving rise to a violation of Article 6, one would expect these cases to be decided on that straightforward basis. The Grand Chamber in Saldus appears to have been particularly influenced by the case of Jallo against Germany, where, in contrast to the present case, violation of Article 3 was also an issue. Accordingly, provided that we are satisfied that the guarantees otherwise available under the Scottish system are sufficient to secure a fair trial for a person who, while detained, is interviewed by police officers without access to a lawyer, and whose trial as responses are relied on by the prosecution, a negative answer to that modified additional question will not conflict with the decision and reasoning of the court in Saldus.
Now, paragraph 27 is a long paragraph, and I don't imagine you're going to read it all out to this, are you?
No, I wasn't, Lord. I'm just responding to the invitation of Lord Roger Lord to look at that.
Well, you say that, as I understand, you say that the analysis in 24 is wrong, quite simply wrong.
Yes, I do. Respectfully. And the other important component of the decision, Lord, and I'm not trying to be disrespectful in any way, Lord, is just to say that it was the point I was just dealing with, Lord, in this section 2 of the Human Rights Act, whether the court ought to follow the decision. And that's the other aspect of the High Court's approach to the matter. And my Lords will have seen that. I don't think I necessarily need to read all of that. But that's dealt with in paragraph 29 and following. My Lords will see. But the court, but assuming we were wrong in our interpretation of paragraph 55, we must consider its effect on the basis of that assumption. And the court then looks at the section 218 of the Human Rights Act, refers to Anderson and Stafford, and discussing Anderson and Stafford, mentions the cases of Robson and Windsor, which were commission cases in respect to the Scottish system. And having done so, the court said, just below letter B, the implications for that system cannot be said to have been carefully considered. In these circumstances, we are of opinion that while the judgment in Saldus commands great respect, we are not obliged to apply it directly in Scotland. Now, this is not, in our view, a situation in which the decision of Saldus requires this court to answer the reference in the Minister's favour. Contrast that with the Secretary of State for the Home Department against AF. We will refer to a number of cases subsequent to Saldus. My Lords will see they're set out. All bear to apply Saldus. None provides any illumination on the principles discussed in it. We did not find these citations to be of assistance. So the court went on to consider that it ought not to follow the decision on the assumption that their initial conclusion was wrong.
Yes.
So, I would respectfully invite my Lords to reach the view that both of those main conclusions were erroneous. I set out on the appellant's behalf some reasons in writing, Lords, that the passage I mentioned in addition to that, and I don't. Perhaps I could just ask my Lords to have regard to that,
yes,
rather than repeat it. So, my Lords, for those reasons, I'd invite my Lords to the view that the approach that the High Court took was erroneous on both of these issues. And for the reasons I've sought to set out to your Lordships, my Lords ought to, in applying Section 2 of the Human Rights Act, follow the Grand Chamber, applying the principles that my Lords in the House of Lords particularly have explained as applicable to this exercise. So, my Lords, if I could then deal, I hope, in short compass with the application of the Saldus principles to this appeal. My Lords, it's set out from the appellant's case as well at paragraph 4.12. But for reasons I've been seeking to submit to my Lords, I say that it can be said in this case that the appellant's rights were restricted, and that the statutory scheme under the Criminal Procedure Scotland Act as it now is does not provide an express right of access, and indeed it's been construed in practice as conferring no such right. That like Saldus, my Lords, and by parity of reasoning, there was a systematic deprivation of that right. And in my submission, if so, there was no justification for the restriction of the right. My Lords will be aware from the appellant's printed cases brief reference to the Thomson Committee report, which my Lords will find excerpts from at volume 10 at tab 270. Lords, for present purposes, I simply wanted to draw attention, Lords, to the policy which seems to have lain behind the matter at 716 of the report.
Would you like us to look at volume 10?
Yes, volume 10, Lord, tab 270. Yes. 716. Lords, at this tab, and for present purposes, my Lords, I just wish to draw my Lords' attention to paragraph 7.16, presence of a solicitor, paragraph 34.
Paragraph?
7.16, my Lord, at page 34.
And the bit you queried in your case.
I do, my Lord, yes. And Lords, it's to this effect that although a person who's been charged with an offence is entitled to an interview with a solicitor, we recommend that a solicitor should not be permitted to intervene in police investigations before charge. The purpose of the interrogation is to obtain from the suspect such information as he may possess regarding the offence, and this purpose might be defeated by the participation of his solicitor. It is for this reason that we recommend in Chapter 5.08 that it would be a matter of police discretion whether to allow the detainee an interview with his solicitor.
Is there any elaboration anywhere else as to what they were thinking of by that remark?
There's a reference at 5.08, my Lords, as well. If I could just draw my Lord's attention to that.
5.08.
5.08, Lords. Yes. It's page 25 of the Thomson Committee report. It's reproduced in the bundle.
Mm-hmm.
Sorry, what was it again?
5.08, my Lord, on page 25 of the print. Sorry, no, they're only partial copies of the chapters. It's chapter 5 at page 25. And this is under the subheading detainees. So far in this chapter we've been dealing with arrestees, but we have also considered the rights of persons who will be detained if our proposals in Chapter 3 are accepted. We've set out these rights in Chapter 3.22 and 3.23. In general, they are the same as those of the arrestee, but we recommend one important difference. Whereas the arrestee will be entitled to an interview with his solicitor in the police station, The detainee's right will be confined to having a solicitor advise that he has been detained. It will be a matter of police discretion whether to allow the detainee an interview with his solicitor. We consider that such a discretion is necessary at the stage of investigation prior to arrest.
It's that last sentence, really, isn't it?
Yes, it is. That's the result.
Might be helpful at some point, Mr. Shedd, at your leisure, we could have the page where it sets out the membership of the Thompson Committee.
Yes, of course, Lord. Yes, of course. Okay. Now, Lords, just taken very shortly, in my submission, looking at paragraph 716 in particular, in my submission, Lord, this apparent justification in my submission is inconsistent with the reasoning of the Grand Chamber in Saldus. And directly so. And for reasons I've been seeking to submit to your Lordships today, in my submission, in the absence of a justification for the restriction, it's enough for your Lordships to reach the conclusion that the appellant has been denied the fair trial to which he was entitled, provided that he's been affected in the sense of the material being used as one of the bases for his conviction. And that's my primary submission, Lord, but in the secondary point I had advanced, Lord, in recognition of the questions your Lordships have raised is whether my Lords are looking rather more broadly at the matter. I simply invite my Lords to the view that in this case it would make no difference to the appellant because his admissions were a significant feature of the case against him.
Where do we find that most conveniently, Mr. Shedd?
The most convenient reference to that, Lord, would be just allow me a moment. Lord, I think there's some reference to the issues in the statement of facts and issues.
Well, I couldn't find anything very clear. That's why I was asking.
I'm sorry about that, Lord. I was tempted to tell your Lordship it would be easiest to find in the Sheriff's report, but I don't think it's necessarily terribly clear from that either, in terms of the detail.
I suppose the problem is the way in which this case has reached us, is it?
Partly, Lord. There is a report from the Sheriff available in the materials, but it's...
Is it in the bundle somewhere?
Yes, it is, Lord.
So where, could we look at that?
What, the Sheriff's? Sheriff's report. The Sheriff's report is page 16 in the core volume in the appendix. No. 16 of the core volume, yeah.
Lord, there are two reports from sheriffs, because one sheriff heard the debate on the minute before the trial in this case, but Sheriff Normand was the trial sheriff, Lords. His report is in the appendix, Lord, part 1.
Page 16.
Yes, I'm obliged, Lord, page 16. There's not much detail given, Lord, on page 17, I'm afraid, of that. The Lords have also been given the transcript of the appellant's interview as part of the materials, and it's fair to say, Lords, and I would acknowledge this, that the appellant clearly makes admissions against interest in relation to the 2 assault charges. The Lords may call to mind he was convicted of 2 charges of assault and 1 of breach of the peace. In respect of the assault charges, he made remarks which could plainly be construed as admissions to those charges on the face of them.
Well, I mean, the Sheriff describes them as incriminating statements. The last paragraph on page 17.
Yes, and I couldn't and wouldn't take issue with that, Lord. And I think it's also reasonably plain, Lords, that not surprisingly the Procurator Fiscal conducting the trial placed significant reliance upon those admissions in inviting the jury to convict.
Is there in the Thompson report, in paragraph 7.16, isn't there really a blurring of the issues? The purpose of the interrogation is to obtain from the suspect such information as he may possess regarding the offence. Well, actually, the purpose of the interrogation is to see whether criminal proceedings should be instigated against him, isn't it? I mean, i.e., the purpose is to get him to incriminate himself. You're not seeking information generally about the offence or whether other people are involved.
Yes, it's absolutely the latter as practice has developed, my Lord. I think in fairness to at the time the Thompson Committee report was being compiled, it was perhaps expected, my Lord, that the matter would be rather broader than that. But as practice has developed, the essence of it is as Your Lordship describes.
Well, there could be situations, I think I suggested this earlier, where somebody was in a state of danger, there was somebody running about who might cause further violence and so on. This individual may have some knowledge of where he is, what he looks like, how he might be intercepted and so on. I mean, the police have at this stage, I would have thought of a fairly wide-ranging remit, and it's their one and only chance to get from this individual what might be useful to them for a variety of purposes. Now, of course, I don't see that as taking away from your basic point. But I think one has to recognise the breadth of the discretion that's given. And
I recognise, my Lord, that, as my Lord says, that the police may incidentally or in other circumstances deliberately set out to seek information, Lord. But generally speaking, Lord, as practice has now developed, it is, in my respectful submission, more common that the situation is as Lord Mance describes. That is essentially the much more common situation. Because I think, my Lords, I haven't gone into this, my Lords, but in the Thompson Committee report, it's envisaged, for example, that detention might be a way for the police to keep a suspect in isolation so that he does not interfere with other evidence or witnesses, and so on. Yeah. But that purpose, my Lord, is very much less common than the one that Lord Mance draws attention to. So, no, I'm sure your Lordships will not be surprised to hear me place emphasis really on the latter as the more common approach now taken.
You look at Appendix Part 2, Volume 2, to go to the Divider 13. You have you have Sheriff Norman's charge to the jury. And page 92, he deals, I don't know where he deals with elsewhere, but he deals in one paragraph with his statement, as I see. And he says at line 11 or so, the accused, you may consider, gave very clear answers to fairly straightforward questions, and it might be that you would consider that it's a very significant part of the evidence.
Yes, I'm obliged, Lord. And that's a reflection, Lord, in part on the Procurator Fiscal's submission to the jury in invitation to convict. And my Lord's, less my Lord's required to have access to it. The speeches are also available as well as the charge, Lord, dealing with that matter. But in this case, Lord, I don't think there's any dispute. I hope this is right. I don't think there's any dispute that these could be construed as very significant admissions in the context of this particular case.
It's very easy for you to say that, but it's not quite so easy to find it out unless one looks for it, Mr. Shedd.
Well, I'm sorry, Lord, it's... I recognise that, Lord, but perhaps, Lord, I could, because I'm conscious of the time, Lord, perhaps I could endeavour to see if a brief summary could be prepared to assist your Lordship rather than having to ask my Lord to go through the matters individually. I think it's fair to say, Lord, and I hope this isn't an overstatement, that they are significant in this context, and I don't think it's disputed that that's so, nor that they were founded upon by the Procurator Fiscal, understandably enough, in his address to the jury and reflected in the Sheriff's charge in that respect.
And is the interview that we're concerned with tab 8 in volume appendix part 2, volume 1?
Yes, it is, ma'am. Between 1503 and 1538.
Dennis, I think I've got that wrong. I beg your pardon. That may be a quote. What I was showing you may be actually part of the prosecution speech. I'm very sorry. I think it is actually. It's Mr. Mackay's speech.
Well,
So it's the fiscal's address. And
No, I think that his charge to the jury begins at page 75 in tab 13 and then goes on in tab 14, I think. And he comes back to it at pages 24 and 25 in tab
I
14.
think the charge starts actually at 14. Yes, he starts his charge at 14.
Yes, I'm obliged to Lord Walker. It's tab 14 in that volume, Lords, and in particular, as I think Lord Walker has noticed, the position as regards the interview is referred to at pages 24 and 25 of the charge to jury.
Yes.
But I'm right, aren't I, that the charge begins at page 75 of tab 13? No.
No, I think not. I think
No.
that's where the procurator fiscal starts at. Yeah, that's just,
Yes, that's right.
I think that's just, Lord, the intervention from the presiding judge at Sheriff at page 75 is just before the procurator
Yes,
fiscal.
the whole charge is at tab 14.
yes.
Indeed it is, my Lord. And 76 and following is the procurator fiscal's speech to the jury.
It's a fairly compact charge.
24.
It is 24 and 25 of the Sheriff's charge.
25, line 7 is the punchline.
Yes. Yes. So the prosecutor was, as we've seen, making quite a lot of it, and then we get the directions.
Yes.
Yeah.
The procurator fiscal argued, apart from anything else, my Lords, again, not surprisingly from his vantage point of view, that the admissions were supportive of the identification evidence which had been given by Mr. Liam Tracy and Mr. John Tracy, and pointed out, broadly speaking, that there had been no challenge in the course of the trial to these matters as essentially unfair.
Well, I think you're sitting there. Your time limit. You've been quite generous to you. Is there anything else that you'd like to draw to our attention?
Two things briefly then, if I could, Lords, very briefly, Lords. I've drawn attention to some international materials about the status of the appellant as a child from an international perspective, Lords, in the appellant's printed case. I recognise, as your Lordships will of course have seen, that for the purposes of the Criminal Procedure Scotland Act 1995, the appellant was not defined as being a child who was 16. But I draw my Lord's attention to the international perspective on that, and of course my Lords have seen what is said by the European Court in the context of those that the Court treated as minors, and I'd ask my Lords to bear that consideration in mind for the reasons which I've set out in the written case. Broadly speaking, my Lords, that leaves two potential issues, my Lord. The first is the one my Lord and the Chair mentioned at the beginning of the hearing this morning. That is the question of prospective overruling.
Yes, I hinted that it might be better, and I'm sure it is better to hear what the Lord Advocate says about that.
Yes, well, I'm obliged, my Lord. I think we'd take it that way round. More than content to proceed on that basis, my Lord. The other issue which remains, my Lord, I think in view of your Lordship's decision this morning as well, is what is issue 5 in the case, which is whether section 57.3 of the Scotland Act has any application in the circumstances of this case.
Yes, that's really her issue too, isn't it?
I'm obliged, my Lord. I was going to respectfully...
I think that makes sense, Mr. Shedd, if we leave that over. You have an hour, according to your own timetable, to deal with these various things on Wednesday afternoon.
Yes. Well, thus far then, my Lord, and perhaps formally I should invite my Lords, subject to these other matters being addressed, to conclude that there has been a violation of Article 6(1), and that therefore, in seeking conviction on these charges, the Lord Advocate was acting ultra vires in terms of section 57.2 of the Scotland Act.
And disposal?
If your Lordships were to reach that conclusion, then in my respectful submission, following the decision of this court in Allison, it's axiomatic that the appellant has suffered a miscarriage of justice in terms of section 106.
Following which decision?
Allison, Lord, against Her Majesty's Advocate.
Tab 1, Volume 1.
I'm obliged, my lord, thank you. Tab 1, Volume 1.
Page. Or paragraph.
Sorry, Lords, I just lost the paragraph reference. Perhaps I could come back to that. It's in our printed case. Lord, it's paragraph 23, Lords.
I think
I'm sorry, Lord. No, that's my fault, Lord.
I think McInnes is the case where we discussed it rather than fully. Volume 2.
Oh, I'm sorry, Lord. It is my fault entirely. It's McInnes. It's also in Volume 2, and the reference is paragraph 23, Lord.
So it's McInnes, paragraph 23, is it?
Yes.
Verse 3.
Maybe paragraph 35.
And this is the
39.
It's judgment of my Lord in the Chair, paragraph 23, at page 271 in the right-hand column of this report. And my Lord there said, it's axiomatic the accused will have suffered a miscarriage of justice if his trial was unfair. The statutory ground for setting aside the jury's verdict under section 106(3) of the 1995 Act enables the appeal court to provide an effective remedy to the appellant for the breach of his convention right. That is done when the appeal court makes its own assessment as to whether the trial as a whole was fair. It will allow the appeal on the ground that there was a miscarriage of justice if it concludes that it was not. And respectfully, Lords, adopting that reason, I'd invite your Lordships to reach the view that that is the conclusion that your Lordship should take, and that being so, my Lord should allow the appeal by
So, but
caution.
that isn't the paragraph which indicates the approach, is it?
Well, it's letter J is picking up the point that I think Lord Brown has in mind, isn't it?
Well, the jury might reasonably have come to a different view.
Well, my Lords had certainly approached the matter that way in the
That's right,
context of
24.
the issues of disclosure and the breach of the duty of disclosure. Lord,
But the test in the next paragraph is whether there was a real risk of prejudice to the defence.
Absolutely, I mean, I recognise that, Lord, but I'm asking the Lords to apply the analysis deriving from Saldus, and what my Lords are inviting me to clarify, as I understand it, is if the analysis submitted to your Lordships from deriving from Saldus is accurate, then what consequence should that bring about? In my submission, for reasons which I've sought to identify from Saldus in the subsequent cases, your Lordship should be satisfied that overall the proceedings in this case should be condemned as unfair. Yeah. And if so, the analysis which your Lordship identified at paragraph 23 is applicable.
The point about the real risk of prejudice to the defence in paragraph 24 is that I was suggesting that it needed a little bit more explanation to see exactly how one works that out. But I'm not sure we need to discuss it in great depth, Mr. Sheridan.
I trust not, my Lord, because my submission is that my Lords were dealing with the context of the breach of the duty of disclosure and the test in that context. It's not part of my submission directly, my Lord, that test is immediately applicable to the present circumstance. But if my Lords were looking for some indication of prejudice, then in this particular case, my Lords, it's present because of the importance of the admissions in the context of this particular trial.
And also because the Sheriff, page 25, said, if you decide what was said as part of the evidence, you may take the view that what was said amounted to clear admissions by the accused that he committed the offence.
Yes, indeed, well, to which there was no effective rebuttal in the course of the trial. So that if the Lords are testing the matter, looking at the proceedings as a whole, following that approach of the European Court, then it produces the same result in the circumstances of this case in my submission for the present appellant. So against that background, Lords, subject to any later arguments, I would invite the Lords to reach the conclusion that the convictions ought to be quashed and the appeal allowed.
Thank you very much indeed, Mr. Shedd. Mr. Richardson. Thank you. Now, Mr. O'Neill.
Obliged, Lord. Just for the lectern. Lords, Justice is very grateful to the Court for granting leave for Justice to intervene in this matter. We have produced a written statement which rather summarises the approach which we will be taking. My Lords, I am conscious that we are interveners. This is not our appeal and we are not the respondents. And therefore I would not wish to detain your Lordships for any particular length of time, and if, with your Lordship's permission, I would, in a sense, assume that one can proceed on the basis of the intervention and perhaps just pick up certain points.
Well, I think that would be useful. We have the written material in front of us, which is very helpful, and if you can pick up particular points.
I'm obliged, my Lord. The position which Justice adopts in this case, my Lords, is that in their view, in the intervener's view, there has been a violation of Article 6(3)(c) in the circumstances of this case. It all turns on this aspect of what Saldus does, and the best analysis, I think, which we can put forward is that Saldus has two aspects. It is, at one level, it's a judicial review of legislation. And what the European Court of Human Rights does is to identify that the legislation is convention incompatible. And therefore, it speaks of a systematic violation of the requirements of Article 6(3)(c), read in the light of Article 6(1). It's saying that the legislation itself, by disapplying the normal right under Turkish law to have a lawyer during a police interrogation, has created a structural unfairness. So, from the point of view of the general legislation, introducing, by its denying the right to a lawyer during police interrogation, a structural unfairness which is then reflected in its finding that one doesn't need to go further to establish, to look at questions of specific prejudice in the specific case. That structural unfairness in and of itself is causative of a violation of Article 6(3)(c). So that's from the point of view, the first point of view, as it were, from the judicial review of legislation aspect. But of course, the court is proceeding on the basis but how does that impact upon the individual? And its other aspect, and the other aspect of its progeny, if one may say, is that the Saldus case reiterates, highlights the fundamental importance of the need to have a lawyer present, right to counsel during police interrogation from the outset. So what can be drawn, we say, from Saldus, is that from a systemic point of view, what there has to be within national law is an instantiation, a recognition of there being a right to have a lawyer during a police interrogation.
Well, during a police interrogation?
Indeed, from the outset of the police interrogation.
But do you mean actually during the question, or do you mean to be consulted before the interrogation?
Well, certainly to be consulted before, and some of the subsequent cases do, I say, go further than the Netherlands Supreme Court says, which is that they say there is only a right to be consulted beforehand, but certainly there's to be involvement of a lawyer from the outset of the police interrogation.
Is there international support for the Bratzer approach that as soon as the person is taken into custody for detention, the lawyer has to be available?
There is, in terms of, I think, Article 93 of the CPT of the rules on for the treatment of prisoners, and clearly the other international materials are to be found in the main judgment in Saldus. But the point I wish to stress, my lords, and why it is that Saldus is apparently under a development, but in fact it's in a sense because the court has been faced with a new situation, is that the court is highlighting that it is faced with a national system which denies the right of a lawyer to be present at all in the Turkish system when it comes to terrorist offences before the special court. And it says, that's why it says that that is a systemic violation of a right guaranteed under the Convention. And so what it's saying is that national legislation has to have a recognition, a provision for such a right. Of course, the right is not an absolute one, but one starts from the basis that there is a right, and then exceptions in the specific case can be justified as to why that might be delayed or refused, or practical considerations might come in. But one starts from the concept that that is one's right. The Turkish legislation was in violation precisely because it took away that right for those accused in terrorist cases. In the Scottish situation, we have the mirror image of what was happening in Turkey pre-Saldus, because you have a right instantiated to a lawyer, but only in terrorist cases, precisely the area where a lawyer is taken away in Turkey.
Yeah.
In Turkey, otherwise, you have a general right to a lawyer in non-terrorist cases. In Scotland, you don't have that right. But the mirror image, the parallelism is there, which is why that we say that one equally can say that the Scottish situation, which does not instantiate that right to a lawyer in non-terrorist cases, is creative of a systemic breach, a systematic breach, violative of Article 6.3c.
So what is the development in Saldus? What's the change?
The only change, we say, my lords, is that it is the first time in which the court is faced with the idea of there being a systematic withdrawal of the right. In other cases, in prior cases, what has happened is that generally, and one see from the international material, there has been general recognition that there is a right to a lawyer. Even in Brioscha against Switzerland, although the terms of the relevant law, are interpreted to give a right to a lawyer after the first interview. So the first time, however, that Saldus has is there is a legislation foursquare, which in terms is applied as meaning and is intended to mean there shall be no right to a lawyer. And that's why it's a systemic violation, as opposed to, well, how is the legislation being applied in practice?
I don't wish to cast any doubt on what you're saying, but you're absolutely sure it was the first time, are you? Was there any of the previous case law which has gone on for quite some time in which that same problem emerged? Or is it just that this is the first time in which the court has actually latched on to that particular problem?
Certainly from my reading of the fairly extensive case law, but I suppose the only two possible cases where it would have been faced with a systemic non-availability would be the admissibility decisions involving the Scottish cases, which would be the complaint of under the current regime. But admissibility decisions don't go into any great detail.
They were commission cases, were they?
I'm sorry, my lord?
commission cases. I think
Yes,
that
they were
Lord
commission
Hampshire
cases.
So I think they were commission cases,
Yes,
and
they
obviously
were.
one understands.
So this is the first time with the court post protocol.
Yes.
Well, I've got Murray wrong, have I? I thought Murray was a case where they don't allow it for 48 hours, I think. Is that not right?
Yes, but Murray is a Northern Ireland case in which, again, under the Northern Ireland provisions, there was a right to a lawyer recognised. It was subject to an exception of a period of 24 to 48 hours.
Known as deferral of access, Section
indeed.
15 of the emergency provision.
Sorry, why isn't that systemic?
Because I say on the analysis I have, it's not denying a lawyer, it's recognising there is a right to a lawyer, but there is a potential in individual cases for that lawyer, for access by an individual lawyer in an individual case to be deferred, and it's set out as a matter of general law. And that's precisely the opposite of the situation we have in Turkey, where one was not allowed any lawyer at all, and the situation in Scotland where there's no right to a lawyer at all, and simply we're told occasionally at the discretion of the police they might accede to a request by a solicitor who happens to
But as far as, if one compares paragraph 63 of Murray with 52 of Saldus, slightly badly translated, but nonetheless there it is. I mean, 52 is just reproducing what they said in 63 in Murray, isn't it? Because in Murray they say the same, national laws may attach consequences, initial stages and so on. Article 6 will normally require the accused be allowed to benefit from the assistance of a lawyer. However, this right, which is not explicitly set out in the convention, may be subject to restrictions for good cause, and so on. I mean, that's all just exactly the same.
Indeed, but then what goes on in paragraphs 56 and 61 of Saldus is the express reference to a systematic exclusion. And that's what makes it different, I say, my lords.
It's just the facts. It's the facts. I mean, it's just the facts on the facts. But I mean, the principle of law, as I understand it, is the one you find in 52.
Indeed, but insofar as Saldus can be seen to be a development, it's because it's dealing with a new factual situation which had not previously been faced with, which is a law which simply will not recognise the right. It's not a law like the Northern Ireland provisions, which recognise the right and then subject to that in individual cases to deferment or exception or the like. It simply doesn't allow for a right in the first place.
Well, the drafting of paragraph 52 does appear to be saying that they were applying the approach in cases such as Murray. Murray is one of the cases listed in subnote 20.
My lords, I'm not saying it's a departure from Murray. I'm saying it's faced with a slightly different situation than was faced with in Murray. And the Lord Advocate suggests that in the case that Saldus is in some sense a dramatic departure from what had previously gone before, and that can't be meant because it hasn't acknowledged that it was moving on and taking a different attack from what had previously been done. Of course, it is applying the Murray case law, which emphasises the importance, the centrality of the access to a solicitor and the potential that can, in an individual case, prejudice a fair trial.
Well, your argument is that it applies the Murray principles because Murray had recognised that there was a right to a solicitor, but that could be dispensed with in certain defined circumstances. Saldus, you would say, does no more than reassert the right to have a solicitor, and because the legislation in Turkey in fact denied that right, then it was consistently with Murray unacceptable as a systematic refusal of the right.
Absolutely so, my Lord, for me that's very helpful. It is, and so I emphasise this notion of it being a systematic withdrawal, which is why in terms, there are two lines of progeny of Saldus, both set out in frightening footnotes, even in the intervener's approach. A line of case law simply repeats, without going into any detail at all of the facts of particular cases, there was no lawyer allowed to be here because of it was a special court case involving terrorist offences. Therefore, there was a breach of Article 6, 3C. It doesn't matter what would have happened if a lawyer had been there. It's a systematic failure. There are those lines of cases, but then there's another line of cases, some of which my learned friend Mr. Shedd has taken your lordships to, which deal with instances in which the national legal system at issue does in principle recognise the right to a lawyer, but has not afforded that right sufficient or given it sufficient strength, or has not applied it or respected it in the specifics of the case, such as to ensure that a fair trial resulted.
You may well be right, Mr. O'Neill. If you look at the date of the measure which introduced the systematic restriction, it's not very far removed from the events that were going around the world in the light of the problems of international terrorism. Our country was doing certain things to try to tighten up, and so were others. And it's the example of straying into repressive measures that has thrown up the problem. I suspect.
Yes, I think that is correct. Well, and the other support I draw from why one focuses on the systematic aspect is that my learned friend Mr. Shedd referred to the case of Dayanan against Turkey. Now, in my analysis, that was the case, your lordships will recall, where the right to silence was actually exercised. But it was a right to silence against the background of the person didn't have a right to a lawyer anyway. So they didn't look into the question of prejudice because the systemic violation was there by the lack of a right to a lawyer. One contrasts that with a case I don't think we've actually looked at yet, with the case of Yildiz against Turkey. And just to be clear, that unfortunately it's only been produced in French. But the interesting thing about that case, and I'll find the reference, is that it is a case in which the systematic violation by Turkey has been removed because it has now changed its law and allowed for a general right of access to a lawyer. And the discussion which occurs then is, well, was there actual prejudice in this case, as you would expect, because there's now recognition of the right to the lawyer. And there's a dissent, 4-3 split decision, as to whether one can ever effectively waive the right which national law has given to a lawyer. That would be a discussion which would never have had to occur, would never have been able to occur in the when it was a case of pure systemic violation. So that's why I say when one reads the Saldo's case law, one has to be aware of which line it is that is following from it. Is that Yildiz? I'm advised that Yildiz is tab 160, volume 6. Yildiz.
But only in French.
It's only in French, I'm afraid. But I've summarised the case at paragraph 213 of our written intervention.
But I mean, it may be, I don't know, you may be right in saying that Strasbourg is going to say wherever there's a systematic denial of access, breach of Article 6, but if it's not systematic, then they look at the individual facts of the case and they decide whether, on the facts of the case, it's a denial. But I mean, that says maybe. It doesn't surely follow that the consequences in terms of whether or not convictions are to be regarded as unsafe and set aside, it's immaterial which it is, does it?
It does not, indeed so, my Lord.
Are you going to address us on that or not?
I'm willingly, my Lord. Yes, I'm afraid I depart from the submissions of the appellant on that front, precisely because I think one has to bear in mind the dual aspect. The systematic violation which existed in Turkey and existed, I say, on the same analysis in Scotland, means that the court can, without looking at questions of prejudice and the like, come to a finding that there's been a violation of Article 6.3c in the light of Article 6.1. It's what I would call structural unfairness. But issues as to what that, and that's one line. Other lines where there isn't this systemic violation, you look at the individual cases and then look at the overall fairness of the trial and then come to a view. That would be, as it were, the second line of decisions from Saldus. But I'm certainly not submitting that a finding of violation because of the systemic violation must result in overturning of every conviction, which is relied on police confessions. That has to be, I say, seen within the context of the particular facts and circumstances of each particular case. But that your lordships can and properly should, because at some levels this is a judicial review of the compatibility of legislation, find that there has been a systemic violation in the absence of an express right to a solicitor for involvement at police interview in Scotland. Now, as I've said, my lords, at some levels your lordships are carrying a dual role as well. At some levels this is a simple criminal appeal on a point of convention law. But it's also a constitutional issue in that the Lord Advocate is not simply, as it were, the Scottish DPP. She is a Scottish minister. And as such, she is responsible under the Scotland Act for ensuring the compatibility of the legal regime in Scotland with the requirements of the Convention. The Scotland Act expressly makes provision for challenges to and remedies in respect of omissions by the Scottish ministers which might be said to be convention incompatible. And in this case, it may be said that the omission, the failure to provide legislation which sets out expressly the right to a solicitor subject to such exceptions is an omission which is convention incompatible. And from a constitutional perspective, and from the Lord Advocate Scottish Minister's perspective, she, along with her fellow Scottish ministers, has a responsibility under the Scotland Act to do something about that.
And so what difference does that make? I mean, she's here, I understand it, as prosecutor and so on. I mean, what are you saying? What would happen?
Well, Lord, I seem to be running this theme of dual aspect a lot, but there's a dual aspect to the Lord Advocate as well. She's not simply,
well,
and I don't think she can...
I'm very well aware of her dual aspects, but today she's here as a prosecutor, as I understand. What does it matter that she's got this other aspect? Supposing there had been a judicial review or something of the legislation, if that had been possible, if it had been a piece of Scottish legislation, the Lord Advocate might have come along as representing as one of the Scottish ministers, but she's not here in that capacity today. She's here as the prosecutor.
Indeed, my lord, my submission or my approach is that I'm not sure that one can so easily distinguish the two capacities as if they were two separate persona.
Well, what does it matter? I mean, you know, if the legislation is a violation, as you suggest it is, does it matter which capacity she's in?
At some levels, no.
What is it adding this? What is this adding?
What it's adding, my lords, is that if I'm correct, that what we have is a systemic violation in the omission of legislation to make provision in Scotland for a solicitor, then we would want the relevant party to be convened if your lordships were to make any kind of remedy or observations in relation to that convention incompatible omission. And I'm saying that it happens to be that the Lord Advocate having the dual function, is here and is a convened relevant party, so that your lordships need not shy away from the constitutional aspect which arises in this case relating to the convention compatibility of the legislation.
I mean, there may be some point, although it's not a very big one, on issue 8, because that is looking to the prospect of a legislative remedy, and it only comes to this, Mr. O'Neill, that if the Lord Advocate is going to address us on that, she's in a position to make some progress in the Scottish Parliament to cure the matter by legislation. I mean, that's all it really comes to. But I don't really think this helps us in grappling with the really basic issues as to whether there was a 57.2 breach. I don't see that.
Indeed, Lord. And certainly the issue of prospectivity is a matter which raises constitutional legislative aspects. And I'm not sure if your lordships would wish me to sketch out our views on that.
I rather suspect not. I mean, I think we know your views very well, Mr. O'Neill, for various reasons. But I think what we're really looking for is the information which Justice has available to us to set Mr. Shedd's submissions into the wider context, because there were some things that he was saying which to some extent were hinting that you had a wider perspective of information to provide us, and that would be extremely helpful if you can do that.
Yes. Certainly from the information that we've been able to gather together, the issue of a right to a solicitor is one which is almost universally recognised from what we can have been able to discover from our research. And certainly there's a very useful report in this, the Spronkin report, which looked at the position in every other member state of the European Union as of last year. And that has been, the relevant aspects of that have been produced. And it appeared from that the only jurisdictions within the European Union which did not have provision in legislation recognising for the participation of a solicitor police interview were the Netherlands, Belgium, France, Ireland and Scotland. Against that background of what the Spronkin report pushed us towards, in that every other country did not have that systemic violation, we then have sought to establish what the reaction to Saldus has been in those, if there has been any reaction. From what our researchers have been able to gather, Lords, we've set that out in the written submissions at page 10 onwards. And clearly in Belgium there has been a recognition that the existing legislative framework within Belgium cannot continue to be relied upon. Court of Appeal in Antwerp relied upon Saldus to rule inadmissible confessions made in an interview without the assistance of the lawyer. And we understand that the Flemish Bar Association has presented a formal opinion asking for a change in the law, and that there is currently a bill before the Belgian Parliament, Belgian Senate, in fact. That again specifically refers to the Saldus case law and why it is that there has to be a change in the law. That material has been usefully, I think, translated by the Crown Office, and it is available in English. The French situation we've set out again with the decision of the Parisian Tribunal de Grande Instance nullifying as convention incompatible a number of interviews which were done without a lawyer being present. And our understanding again is that an amendment to the French Criminal Procedural Code has been brought forward as a response to Saldus, but that does not allow for access to a lawyer during the interview itself. The Netherlands position, I think Mr. Shedd has looked at, and it is, as has been discussed, whereby the Netherlands, Supreme Court of the Netherlands, following a decision of the Advocate General, is of the view that there should be participation by a solicitor, at least in terms of being able to access and consult with prior to interview. In Ireland, it's not clear that there's been much reaction to the decision of Saldus as yet in the Republic of Ireland. But yes, there is a right to counsel within the Irish Constitution that's been read in, but it's not a right of availability at interview. So from a European Union perspective, at least, the vast majority of states already have provision for lawyers to be available at police interview. The majority, those ones which did not have made changes or are in the process of making changes to their legislative provision. The Netherlands Supreme Court, as we've seen, said it wasn't competent itself to rewrite a law, but the prosecutors have set out modified guidelines which are currently being followed on an interim basis. And as we've seen, also Turkey has changed its law to allow for the general access, again, in all cases, and has taken away the disapplication in relation to terrorism cases. Lords, again, in terms of our review of the English-speaking legal world, we've set out our understanding of the position in England, Wales, Northern Ireland in PACE, which again sets out a right subject to express and specific exceptions. Canada, again, the Canadian Charter of Rights and Freedoms allows for the right specified, and notes that a detainee is not only to be informed of his rights but also to obtain advice as to how to exercise his rights under the Convention, and notes the immediacy of the need for legal advice.
It looks as though a lot of these systems concentrate on the presence of a solicitor before questioning. Is that right? I mean, again, I come back to the question I put to you earlier, whether there's anything that goes quite as far as Judge Bratzer went in saying that it had to be provided at the moment, from the moment that custody begins.
Well, I think the general approach, my Lord, is that the, as it were, the interrogation begins after the solicitor has got there, as it were. It's, I know your Lordship was asking, putting forward various scenarios. Well, what if the solicitor is going to take some time to get there and might not be available and the like? But I think the approach, as it were, is that the questioning will only begin formally once the solicitor has been there for the advice, and the time starts running once the
Well, there's obviously flexibility
arrived.
if you take that approach, because you can wait until questioning begins.
But
what's troublesome about the Bratzer approach is it doesn't have that particular flexibility in it.
Well, it's, in a sense, it depends on what the starting point is. And it's the clearly, as a matter of practice, the question of the ensuring the presence of a solicitor as soon as somebody has been arrested is not something that can be magicked up, as it were. And the only thing that's specifically in the control of the police would be as to whether or not they would start the questioning. So I think it's just a question of the police waiting to start any questioning until such time as the solicitor has been found who can come and give such advice as is necessary. So I think one can get round it that way.
Judge Bratzer is saying, as I understand it, that what you've not got to do is to, I may be wrong, but I mean, what I read him as saying is one isn't to limit the idea of having a lawyer present to the situation where the chap is actually going to be interrogated. It's more general than that, and that if he's just been detained without anyone actually interrogating him, then in that situation he should have a lawyer. In other words, he's saying it would be wrong to limit it to the situation where the chap is actually just being or about to be interrogated. Well, that's what I read him as saying in page 442.
Certainly, my reading of that passage, my Lord, is that Judge Bratzer, which as I had read it, is emphasising that there's a violation of Article 16C because of a systemic aspect from the outset. It doesn't matter that the question of prejudice that may or may not result. It doesn't require the specific facts to be looked at.
No, but he was looking at a Turkish case where, especially where state security was involved, the suspect could have been held in detention for days. There's no reason for thinking that Judge Bratzer had in mind the situation where there was an absolute maximum of 6 hours detention.
I'm sure he didn't have that, the Scottish scenario specifically in mind, but in his emphasis that it isn't fact-specific, I think he is saying that what is problematic or what is violative of the Convention is a legislative schema which denies access, denies the existence of a right of access to a lawyer. And I think that's compatible with the analysis that is why the Scottish legislative schema is equally violative.
Well, he chose his words very carefully. The denial of access to a lawyer from the outset of the detention of a suspect, which in a particular case results in prejudice to the rights of the defence, may violate Article 6. So that's not systemic.
The previous sentence, Lord, it would be regrettable if the impression were to be left by the judgment that no issue could arise under Article 6 so long as a suspect was given access to a lawyer at a point when his interrogation began, or that Article 6 was engaged only where the denial of access affected the fairness of the interrogation of the suspect. I mean, he's chosen words carefully there, which to me is a systemic approach. But certainly he's concurring in a judgment which says in terms that there is an issue, a systemic failing here in the Turkish situation.
On the question when the obligation begins, I mean, there are two cases, aren't there? There's Dayanan and Turkey, 13th of January this year, as from the first interrogation of a suspect. And then there's Zaichenko in Russia, 18th February, which is the moment of a charge may occur pre-trial, for example, at arrest, date of notification that the applicant would be prosecuted, or date when preliminary investigations were opened. Under Article 6.1, the court adopts the date of official notification of the allegation that the applicant committed an offence. Well, that, I would have thought, reasonable, if you're detained on reasonable suspicion, that's going to satisfy one of those. Date when preliminary investigation opened, at least.
As from first interrogation of a suspect is simply repeating what's set out in paragraph 55 of Saldus as a starting point, which Judge Bratza is concurring in. Of course, he's not dissenting in his opinion at all. Zaichenko is a slightly stranger case, well, factually a bit more complex in the sense that it is the issue of questioning at a roadside stop of a car.
One has the feeling he was very lucky in Zaichenko.
But there wasn't a finding of Article 6.3c in Zaichenko, paradoxically, but there was a finding of breach of the privilege against self-incrimination under Article 6.1. So they were drawing a line in terms of when you get to have a lawyer, and they said that the important thing which distinguished Zaichenko on the facts was that there wasn't that element of compulsion, of restriction of freedom, which they say would bring in the Article 6.3c aspect. So, but they did say that the fact that he did volunteer this was unfair, but it wasn't a breach of his right to a lawyer. So the aspect of detention is being emphasised, of being restriction on one's movement, as that's when you should have your lawyer in as a period.
It's good to know that according to your friend the Spronken report, in Scotland there is a right to consultation prior to police interrogation. So it's very good to know that that's the case. So I think we can all go home, I think.
The I'm certainly going to be. The United Nations, my Lord, has also been informed by the UK government that there's a right throughout the UK.
Throughout the UK?
Yes. So perhaps things aren't as...
The UK government simply referred to paste.
Yes.
It doesn't seem to be conscious of...
the difference. These things happen occasionally.
Tabs 257.
But in general, again, the survey, very exhausting survey of what's been happening in the English-speaking world shows a general recognition, I think, apart from the Northern Territory of Australia, to the right to have a lawyer available during the issue of police interview. And we conclude at paragraph 4.37. Despite differing approaches, there's a coherent theme amongst the nations that the right of access to a lawyer on being taken into police custody is fundamental and, if not observed, can lead to the exclusion of evidence. And emerged in recent times the right to consult is equally imperative in interview for most jurisdictions, although it's clearly a matter for some development. The next section, we look at other relevant international materials, and that's the European Convention for Prevention of Torture. Again, this material has already been referred to, Your Lordships, in terms of general reports have been made, in which the committee recommends the right to and access to a lawyer from the very outset of deprivation of liberty, which should include a right to contact and visiting, as well as in principle the right to have the lawyer present during interrogation. And they set out why they talk about the particular vulnerability on deprivation of liberty. The CPT, as we've noticed, has made several visits to the United Kingdom. It observed in England, Wales and Northern Ireland the safeguards applied in a satisfactory manner, although noting historical problems with access in Northern Ireland in relation to counter-terrorism issues. And they note what they were told when they went to Scotland, however, that it was not usual for persons detained under Section 2 of the Criminal Justice Act to be permitted to speak with a lawyer. So it sums up what the practice is, and my submission, if that practice were before the European Court of Human Rights, they would simply say, well, Saldos has said that practice of it not being usual for have access to speak to a lawyer is not compatible with the rights under Article 63C.
In paragraph 5.6, they note the government's response without criticism. Perhaps that's what is normally done, is it?
The government gets to have the last word. It just responds. There isn't a third report. It's the CPT reports, then the government responds to it. So it will attempt to explain any criticisms made.
It doesn't. 5.6 doesn't appear to correspond with the reality. Is that right?
That's certainly what I'm advised of the.
Well, I think I was hinting at the point that I'm surprised they didn't actually say that, but maybe you don't. Maybe for comedy or whatever it is, you don't actually criticise. You just note the report and people can take from it what they may.
Well, doesn't it beg the question of what are justifiable reasons? I mean, if the justifiable reasons are that having solicitors there will impede the progress of the interrogation, then that really covers the whole story.
And indeed, in the words of the Thompson Committee, Lord, it might encourage criminals to stand on their rights, with a particular phrase used in paragraph 2.3 of the Thompson Committee.
We didn't see that.
No, we didn't see that.
Is that in the bundle?
It is in the bundle, Lord.
That's ought to.
270.
2.3.
2.03. It's 270. Volume 10, tab 270.
Yeah.
And the paragraph?
2.03. Where it says, any solution to the individual problems under consideration must necessarily be a compromise between these two interests, that of the public as represented by the police and that of the individual. It must meet the requirements of the police for such powers as are necessary to enable them to carry out the duties of crime detection in the interests of society without giving them power to ride roughshod over individuals. It must safeguard the individual's right to go about this lawful business free from unreasonable police interference and his right to have his personality and human dignity respected when he is in the hands of the police, without creating a situation in which criminals can render the investigation of their crimes difficult or even impossible merely by standing on their rights.
So that's a recognition, is it, that if you give a caution without legal advice as to what the implications are, it really doesn't mean very much?
That certainly seems to be, must be the necessary.
I mean, presumably he was required to give a caution at the time of this.
Yes,
yeah.
Indeed.
There's a great deal of emphasis on rights and obligations of the public and the police and so on.
And the police as determinative of the public interest. it was a report from 1975.
The practices, police practice accepted as fair by the public, including criminals, though they may be technically illegal or at least
Yes.
Yeah.
Happy days. Returning to the written submissions, we note the Human Rights Committee, paragraph 5.8, whose reports have raised concerns about the current practice under the Terrorism Act and delays of responses, and the Human Rights Council, there was paragraph 5.11, we note the most recent periodic review touched on the delay of access to a lawyer, and particularly under the counter-terrorism provisions. But this is where the UK asserted that an immediate right to have access to a lawyer is already provided for in UK legislation referring to the provisions under PACE. I'm reminded also, my lords, that this business about responding to what a lawyer might do, as in encouraging criminals to stand on their rights or exercise their right to silence, there in fact is an empirical study which was looked at as to what the impact was of having a solicitor present following the PACE reforms, which was referred to favourably by the New Zealand Court of Appeal. We note that at paragraph 412 and at 413. The empirical study is number 250 at volume 9 of the bundle of authorities. And in summary, what that study said was that police officers actually found it beneficial to have a solicitor present.
Sorry, what was the reference in volume 9?
250.
Thank you.
It's by Professor David Dixon, Common Sense, Legal Advice and the Right to Silence.
So this is a study of practice in England?
It was. And noting that whilst common sense may suggest that legal advisers would obstruct police work by asserting rights and demanding due process, the study in fact showed that police officers often saw benefits from the legal advice which suspects received, as it might lead to, in fact, earlier confessions, and also can explain situations to the suspect, gain confidence and improve communications. So it's not all about say nothing.
It's all, the same phenomenon occurred with the introduction of PACE, didn't it? I think originally resisted, but actually ultimately very much welcomed, because it avoided endless cross-examination in every case about whether the police officer had made up his notebook and
yes. And this is a study.
That was adequately dealt with by tape recording in Scotland.
Yeah.
I mean, that killed that particular industry.
Yes. In terms of the making of notebooks, but in terms of improving communication and the like, and clarifying situations, I think the Dixon study, which is a study of England and Wales post-PACE,
whether people have been given proper facilities and all that now had to be recorded, and it completely changed the way in which the criminal justice system operated in court. Actually,
indeed.
Nobody got convicted, though.
I'm conscious of the time, my lords, and we note at paragraph 5.12 of our intervention that in our conclusion on international obligations, that no mention was made of differing practice in Scotland in the Universal Periodic Review to the UN. Equally, it applies to the Commission on Prevention. CPT and access to a lawyer are not borne out in practice. In practice, lawyers don't get to see clients in Scotland if they ask. The UK has asserted it complies with the essential protections, but this is not the case. The process illustrates that whilst the UK attempts to present a united front in its international obligations and reports to bodies, there is confusion as to what protections exist across and within the UK for citizens of the Union, which don't take account of the peculiar situation which exists in Scotland. Our section 6 sets out the contrast, I think, between the Thompson Committee report and the Royal Commission, which resulted in the introduction of PACE. the Royal Commission, which reported over the course of 3 years from 1980 onwards, carried out quite substantial research and commissioned its own original research and various matters, various visits carried out abroad and the like, and the result was, in effect, the recommendations which formed the basis for peace. So the fact that Scotland and England diverged was not because of any great aspect of principle or historically Scotland is different from England or there are different structures because we've got a better adversarial system. In a sense, it was happenstance. Thompson Committee reported earlier, was acted on earlier. The Royal Commission was round about the same time, was a bigger commission, did more research and came up with differing views, which it would turn out from the empirical research has not resulted in the sky falling over the criminal justice system in England and Wales.
Well, Mr. O'Neill, I think we're going to have to end it there. But we have much of your material in writing, for which the court is extremely grateful.
I'm obliged.
Thank you very much. Well, Lord Advocate, I'm very sorry, due to matters which are no concern of your Parliament, we have to spend the morning doing other things. But tomorrow at 2 o'clock, we look forward to hearing from you. And the timetable I have is that you have to 3:30. Yes, until 4:30, I beg your pardon, and then from 10 until 1 on the Wednesday, and then Mr. Summers, a shorter period for you, and then Mr. Shedd's reply.
That's understandable.
Thank you very much.